A divided New York appeals court on Thursday threw out a $500 million judgment against President Trump, eliminating an enormous financial burden while preserving the fraud case against him. A remarkable turn in the battle between the president and one of his fiercest foes. While harm certainly occurred, it was not the cataclysmic harm that can justify a nearly $500 million award to the state, wrote Peter Moulton, one of the appeals judges whose lengthy and convoluted ruling reflected deep disagreement among the five-judge panel. While the court effectively upheld the fraud ruling against the president, several of the justices raised major questions about the case, which was decided by a state court judge. And their decision allowed Mr. Trump to move to New York's highest court, giving him another opportunity to challenge the finding that he was a fraudster. Despite the complexities, Thursday's ruling handed Mr. Trump a financial victory and a modicum of legal validation. It represented a setback for New York's Attorney General, Letitia James, who was one of the president's foremost adversaries and a target of his retribution campaign. The case had been a career-defining victory after she campaigned for office promising to bring Mr. Trump to justice. Mr. Trump responded on social media declaring victory and praising the court for having the courage to throw out this unlawful and disgraceful decision. Alina Habba, who had represented Mr. Trump in the case and is now the top federal prosecutor in New Jersey, said that the decision confirmed what we have said from the beginning. The Attorney General's case was politically motivated, legally baseless, and grossly excessive. Still, the decision fell short of the full vindication the president had been seeking in his fight against Ms. James. In denying Mr. Trump's bid to throw out the case, the court kept in place the ruling that he had committed fraud, an ignominious distinction for a sitting American president. Ms. James, in a statement, said that the court had, quote, affirmed the well-supported finding of the trial court. Donald Trump, his company, and two of his children are liable for fraud. She pledged to appeal, adding, it should not be lost to history. Yet another court has ruled that the president violated the law and that our case has merit. Ms. James filed the case against Mr. Trump and his family real estate business in 2022, accusing them of inflating his net worth to obtain favorable loan terms. After a months-long trial, the judge overseeing the case ruled last year that Mr. Trump was liable for fraud, denting the mogul image that enabled his political rise. Thursday's ruling came almost a year after judges at the Appellate Division for the First Department heard oral arguments, an unusual delay that reflected the legal and political complexities of a case against a sitting president. Ultimately, the case was so divisive that the 5 appellate court judges failed to form a true majority. Justice Moulton's opinion upholding the case and wiping out the financial penalties received one additional vote, from the Chief Judge Diane Renwick. Another judge, David Friedman, who has been skeptical of the accusations for years, wanted to throw the case out entirely, believing Ms. James had lacked the power to bring it. 2 other judges concluded that Ms. James had the authority to file the case, but wanted to provide Mr. Trump a new trial. Those 2 judges, arguing that, quote, a remarkable situation has necessitated a remarkable solution, agreed to let the fraud judgment stand so that the case could continue to a higher appeals court. The judges, John Higgett and Lynette Rosado, said they did so after much consideration with great reluctance. The 4 justices who formed the reluctant majority were appointed by Democratic governors. Justice Friedman was appointed by Governor George Pataki, a Republican. In his own lengthy opinion, Justice Friedman pointed out that he and 2 other judges had believed that the judgment against Mr. Trump should be thrown out, but he and the other 2 dissenters could not agree on an effective remedy, allowing the judgment to stand for now. Justice Friedman also blasted Ms. James for comments she made while running for office in 2018, in which she pledged to investigate Mr. Trump, calling his presidency illegitimate, and saying she would join with other attorneys general in seeking to remove him from the White House. Even the judges more sympathetic to the Attorney General's case agreed that Justice Friedman's criticism of her comments was merited, though they noted that Mr. Trump's claims of political persecution had already been considered and rejected by the court. From the beginning, the case infuriated Mr. Trump, who has sought revenge against Ms. James since before he retook the White House in January. His Justice Department has opened inquiries into her and her office. One is a criminal investigation into her personal real estate transactions, while the other is a civil rights inquiry into her office for its conduct in investigating Mr. Trump. A lawyer for Ms. James, Abbe D. Lowell, has called the allegations against her baseless, and it is unclear how far the case involving her real estate transactions has progressed. But this month, a Justice Department official and Trump activist, Ed Martin, was put in charge of the case. Last week, Mr. Martin appeared outside Ms. James's Brooklyn home and posed for pictures, a stark violation of Justice Department rules. Mr. Martin was warned that such actions could damage any case against Ms. James, but he appeared unchastened. On Wednesday, he posted a picture on social media of himself outside her house. Mr. Trump, in his appeal, argued that the roughly $450 million judgment, currently sitting at more than $520 million with interest, was excessive, given that his lenders never lost money, and that the Attorney General's office was meddling in private transactions. In Thursday's 126-page decision, Justice Moulton agreed that the punishment did not fit the wrongdoing. He concluded that it was an excessive fine barred under the Constitution. He rejected the idea of a new trial, however, noting that it is difficult to imagine that a trial could proceed while one of the principal defendants and a central witness is President of the United States. Justice Moulton also wrote that the evidence clearly demonstrates defendants' liability, highlighting the volumes of evidence against Mr. Trump, his two sons who run the family business, and some of the company's top executives. The ruling maintained the result of a case that put Mr. Trump's fantastical claims of wealth on trial, though the shaky nature of the panel's findings only reinforces the importance of any conclusion reached by New York's highest court. When the state court judge, Arthur F. Engoron, imposed the $500 million judgment in February of last year, the eye-popping sum appeared to represent an existential threat to the Trump Organization. Mr. Trump's company struggled for weeks to line up a bond of that size that would allow him to appeal the judgment without paying the state. When Mr. Trump came up short, the Attorney General's office appeared poised to freeze some of Mr. Trump's bank accounts until the appeals court intervened and allowed him to post a smaller bond. The court also did not force Mr. Trump to pay the penalty while he appealed the case. Much has changed since then. When Mr. Trump was still facing multiple criminal indictments, even, as he tried to reclaim the White House. Not only did he win re-election, a victory that effectively eliminated his criminal cases, but he has reaped a windfall from his personal business ventures. His foray into the cryptocurrency industry has been particularly profitable, adding billions of dollars in paper value to his net worth, removing any real threat to his financial stability. The civil fraud trial stemming from Ms. James's lawsuit was not decided by a jury. Instead, the power belonged to Justice Engoron, who found after months of testimony that Mr. Trump had lied to his lenders about the value of his properties and sought to claw back his ill-gotten profits and interest savings. The judge also delivered a sweeping array of punishments that took aim at Mr. Trump's way of doing business, including barring him for 3 years from serving in top roles at any New York company, including portions of his own Trump Organization. And he inflicted a 2-year ban on Mr. Trump's adult sons. The appeals court, while eliminating the financial penalties, has now given those other punishments the green light. One of Justice Engoron's punishments that had already kicked in, the installation of an independent monitor to keep an eye on the Trump Organization's business practices, is expected to continue as well.